Chill, your home for all things legal shenanigans. I'm Stephanie, your friendly neighborhood lawyer. Well, not your lawyer, which brings me quickly to our disclaimer. By watching this video, you understand and acknowledge that this video is for entertainment purposes only, and you acknowledge that you have read the full disclaimer down below in the description box. Today, we are going to talk about the potential lawsuit. A few media outlets have reported that she may be suing Gorilla Glue. She has not confirmed whether or not she is suing. First and foremost, if you are not familiar, she unfortunately put Gorilla Glue in her hair, which has now been stuck on her head for over a month. She now has a YouTube, so I've linked her YouTube below. By watching her channel, you can help support her, and hopefully she will be able to get that off, and medical professionals are able to help her. So with that being said, today we are going to do a hypothetical lawsuit, a what if, because to be quite frank, the one thing for certain that will come out of this, for those of you that are in law school, this will likely be your torts exam if you have a witty teacher, or it'll be on the bar exam because this is a prime tort case. We're going to go over a few non-lawyer civilian theories that I've been seeing floating around the interwebs about whether or not she can sue, what would be the outcome of said lawsuit. So we're going to first and foremost go over whether or not the label on Gorilla Glue is misleading. Then we're going to go over, is this similar to the McDonald's case? Because surprisingly, I've seen a lot of people mention this McDonald's case, which is a very specific case, which had a very large award to the plaintiff for a very specific reason. We're going to go over that. We're going to go over potential additional lawsuits. So potentially, can she sue Got to Be Glued? Can she sue the hospital? Can she sue the seller, whatever store she bought the glue from? So we're going to go over that today in turn. Now again, remember, this is a hypothetical lawsuit at the point of this filming. She may or may not sue. My strong suggestion would be no, and we're going to go over why. So first and foremost, is the product label misleading? Product, I'm going to put it right here. In the front of the product, you see all the things it tells you it's for: hardwood, surfaces, metal, etc., not humans. Specifically, the label says do not get it in your skin or on your eyes, anywhere near your body. So that has sparked a lot of people to say, well, it doesn't say hair. Case in point, if you've seen the video, first and foremost, scalp is skin. It is partially on her scalp, so yes, that would count as skin. Now, does hair count as skin is then the question. So to back up 1 second, we are going to go through we have more facts now than we had at the beginning of this. One fact that is going to be super important, and I will link the interview below. Tessica gave an interview, what day is it? Yesterday, in which she stated that yes, she knowingly put the Gorilla Glue on her hair because she ran out of Got to Be Glue sprayed. A lot of people were saying, oh, maybe she took Gorilla Glue for Gorilla Snot hair glue. That's not what she said. She said she knew and she put it on her hair and that she thought it would wash off in 3 hours. The reason why this admission is important, if she were to sue, this admission is the first thing that Gorilla Glue and their legal team would pull up and say this case needs to be dismissed. She purposely put it in her hair. So with that being stated, the next legal analysis would go to, if the judge was like, okay, yeah, she did, but you should have fixed the label. The next legal analysis would then be, okay, if the label doesn't say hair, what qualifies as skin? Now, you're probably looking at me crazy, like, Stephanie, skin is skin. Yes, technically, skin, hair, and nails are all made out of the base protein, which is keratin. You know who would decide this? Not me, not you, not the Google. Expert witnesses. Expert witnesses would come in and then try to prove whether or not, so depending on which side, whether hair qualifies as skin, which is very interesting. So expert witnesses, that's like part of their job. Expert witnesses can be anybody. Like, for example, I work in tech. I could be called in to be an expert witness about SaaS, software as a service. So these expert witnesses would be most likely dermatologists, some doctors, maybe, since we're talking about proteins and whatnot, maybe some chemists to talk about what is the base protein in hair and skin. Are these the same thing? Which is pretty interesting. So they would decide that. Then one of the main things, which is going to be a huge bar to her suing Gorilla Glue specifically, Gorilla Glue will assert the reasonable person standard. The reasonable person standard is simple. The reasonable person standard is, would a reasonable person of this same age do this same thing? So in this case, would a reasonable 40-year-old put Gorilla Glue in their hair? The answer practically is just no. And the answer practically is no because this has never happened before. So under the reasonable, I don't know why I can't say reasonable today. Under the reasonable person standard, it used to be called the reasonable man standard when I was in law school, and because the law is sexist, and I refuse to say the reasonable man standard because it just should be reasonable person. So under the reasonable person standard, she would be barred from suing and it would get thrown out. to be quite frank, for almost any claim against Gorilla Glue. With that being said, I see a lot of people then saying like, oh, maybe they'll settle with her. In my learned opinion, they're not going to settle with her for one specific reason. This will create a precedent that people can file frivolous lawsuits against them. So settling with her would create that public precedent, and they don't want that. So it's worth the money to them if she were to sue. Again, it's a giant hypo if, to then squash it in court and be like, no, you can't sue for these types of things when you cause the problem. And with that, they would also bring up contributory negligence. So under tort, defendants are allowed to bring up various defenses when they are sued. One is contributory negligence. Contributory negligence basically states if you, the plaintiff, contribute at all, it's very fact of the matter, to the problem, you get $0. So if you applied the glue, you cannot sue. Under contributory negligence, she wouldn't get anything. Under comparative negligence, however, comparative negligence is a percentage allocation if you and the plaintiff are wrong, both the defendant and the plaintiff. So let's say here the judge is like, you know what, y'all should have really put hair there, but scalp is skin again, so let's cut off, that 40%, 30%-ish of the hair you guys are not liable for because it is on her scalp. The rest of the 70%, okay, kind of. But out of that 70% that maybe Gorilla Glue is liable for, if in an if situation, because remember, the judge would then say, okay, this is actually 90% likely her fault because she has already admitted, link below to the interview, she has already admitted that she purposely sprayed the glue on her hair when she shouldn't have. It says permanent adhesive on the front of it. So the judge would likely then maybe 10% fault to Gorilla Glue, if that, highly unlikely. I highly doubt it. Her suing Gorilla Glue is a moot point, and to be honest, the only reason why this would even make it to filing a complaint is if, unfortunately, a lawyer with no scruples has told her that this is a good idea. And yes, unfortunately, a lawyer will get paid regardless. Win, lose, rain or shine, you still pay that attorney. So that's always something to think about. I have so many people that come to me and they're like, A, I don't do private practice anymore. But B, I always tell people half the time you don't even need a lawyer. Like, you're fine. You gotta just, move on. Another claim she might bring up is emotional distress. The reason why emotional distress would be an awful claim to raise, because it is documented now that she's posting memes, that she's making jokes. If I see it and if you see it, and that means Gorilla Glue's attorneys have seen it and they screenshot everything. Lawyers love screenshots. All of my friends, all of my family, all of my coworkers now keep folders of screenshots. Because yeah, that's the best way to end an argument. Just bye, quiet, with the screenshots. So for those of you that maybe are, unfamiliar with the Black culture, stiff wear is a joke. Stiff wear my hair is, in my opinion, honestly, the best joke I've heard all year. So she's quite funny. She's taking this entire thing with such a positive attitude, but her jovialness and her showing that like, oh yeah, I'm being happy about it, a defense lawyer would then come back and be like, see, nothing is wrong. And of course, notwithstanding, we have seen the videos, of course, her trying to remove the product from her hair is very painful. This is not what we're talking about. We're talking about specifically her, on her Instagram, on her TikTok. Defense would then use that and say, okay, you can't sue for emotional distress, because emotional distress is, woe is me, my life is over, all those things, you have to prove them. So, for example, if you ever get an insurance claim and you sue your insurer, and you say like, oh, my leg is broken, the minute the insurer sees you stand up, they will troll you on Instagram, take screenshots, and then claw back the insurance money. FYI. So let's talk a quick second about the McDonald's case and why you should not compare this case. Why you should not compare this case to the McDonald's case. In the McDonald's case, this woman sued McDonald's for giving her extremely hot coffee that's then spilled on her, gave her third-degree burns. Now, mind you, on McDonald's cup, it does say caution hot, right? It was always there. However, the reason why she won so many millions of dollars is because McDonald's had received, prior to her spilling the coffee on herself, hundreds of complaints that the coffee was too hot. So McDonald's was aware there was an issue. Here, it's safe to say, as far as we know, and this would be for Tessica's attorneys to then look and see, that Gorilla Glue has not received such complaints about hair, about people spraying it in their hair. Second, now, if they have, then maybe she has something, then maybe there's a case, but again, the reasonable person standard would come in and likely squash that. So next, in the McDonald's case also, there is a duty of care as the provider, the person who's giving the food, that the food is edible, that the food is safe, the food is doing all these things. It's food and beverage. The temperature in the McDonald's case was 190 degrees Fahrenheit. Well over the allowed amount. Your body is only at 98.6 degrees. That's why McDonald's was found at fault. Here, Gorilla Glue, it says on the front of the can, this is for wood, this is for metal, this is for this. It's not the same. It's nowhere near the same. And if her attorney were to ever assert the McDonald's case as precedent, the judge would literally wipe the floor with them. Judges can be very snarky because there's no one to check them. So they just, say what they want to say, and a judge would literally read them for filth. So no, the McDonald's case is not the same. It is very different. Get that out of your mind. Let's talk about additional lawsuits, because actually, if she were to look at additional lawsuits outside of Gorilla Glue, I think she might have a small case depending. So, which, first and foremost, she eventually, after a month, went to the hospital. So if she were to sue the hospital and claim like, hey, I came to the hospital, the duty of care that you as the hospital were supposed to give me was breached. You didn't check my wounds, you didn't help, you didn't do all these things. So far, I haven't heard her say that or seen anything of that nature, but potentially if those set of facts were there, maybe she could sue the hospital. The hospital will then counter and say, we are a hospital. And this is a chemical issue. You need to see a chemist. We did the best we could. So what is the duty of care of the ER? Like, how much does the ER have to do to make sure that they're not getting sued? And they would go back and forth about that. The duty of care for the ER for, like, for example, if you have a wound, if you have certain things, is there. But if you have purposefully put adhesive in your hair, the duty of care is very different, because a registered nurse is not trained to deal with this type of situation. Only person, in my opinion, that she could sue, that she would actually win, if she bought this from a physical store or online store where they had put the Gorilla Glue next to hair glue products. That is the only place, in my opinion, that she would actually win. This is nowhere near in the store next to each other. Gorilla Glue spray is in the hardware section. Gorilla Glue is all in the hardware section. Gorilla Snot Glue, Gorilla Got to Be Glued, all of that is in the hair section. They're completely separate. So we've been in the store, we've seen that, so I highly doubt that that's the case. If she was at an online retailer, so say for example she went on Amazon, Target.com, Walmart.com, this is an example, remember, and she typed in hair glue and then Gorilla Glue spray popped up, she could totally sue them. Again, that's if those facts were there. I don't think they are, but if she could prove that, then yeah. And say like, hey, this is your fault, I bought this from you. And then the store would she would then sue the store, and the store would then be like, okay, yeah, error on our part, but you should have read the label. So then comparative negligence would do percentage-wise who's more wrong than the other one. So I think that would be the best way for her to get any type of settlement out of any of this, in my opinion, if those facts are there, and most likely those facts aren't there. With that being said, I've seen a lot of people then being like, oh, well, Got to Be Glued should change the name of their hair care. First of all, do you know how expensive that is to redo all of your trademarks, all of your marketing, all of that? That's not happening. Second of all, Got to Be Glued cannot be sued because someone else used their product, has been using their product is working as it's intended to work, and then someone else used the idea of glue to then use something else. Tangentially, it doesn't make any sense. Also, she has already admitted that she purposely put Gorilla Glue spray in her hair knowing it was not for hair. So that would ruin that entire argument. The lawsuit that actually would make sense, which these facts do not exist, but for those people that kind of are like, oh, maybe we could do that, can't do that. What could happen if these facts did exist, if Gorilla Glue spray had actually marketed their spray similar to Got to Be Glue, put it in the hair section, decided like, yeah, we're also going to use a blue bottle, yeah, we're going to change the packaging, do some funny business, then she could sue Gorilla Glue. That's not what happened. Got to Be Glued is nowhere in this equation. Their product is working as it should. Their product is minding its own business. Hope you enjoyed that quick hypothetical court case. And we'll see. I really do hope that she doesn't sue and that she has good counsel to advise her that this is a bad idea. Because at the end of the day, a lot of these lawsuits, unfortunately, The McDonald's case is a 1 in a million because at 190 degrees and third-degree burns, they deserve to be sued. It was a hot mess. When you cause the problem, it creates other issues. Also, remember, the lawyer who's hyping you up to do these things will always collect their check. Always. They're gonna do the work regardless. So just because an attorney approaches you and says something is a good idea, doesn't mean it's a good idea. There's a reason why people have disdain for some attorneys, which irks my nerves, but I'm like, well, y'all keep doing this to yourselves. And as an attorney, I have disdain for them. There's a reason why there's a word ambulance chasers. Annoying. People that go out of their way because that's how they make money. They make money off of these lawsuits. So they have to find a plaintiff to file the lawsuit. The practical answer is yes, you can sue. But the more important answer is, will you win?